Welcome back to the Thinking Crypto podcast, your home for cryptocurrency news and interviews. With me today is Paul Grewal, who is the Chief Legal Officer and Corporate Secretary at Coinbase. Paul, it's great to have you on the show.
It's great to be here, Tony. Thanks for having me.
Paul, there's lots to talk about. Of course, I'm a fan of Coinbase. I've been using Coinbase for years, so I got questions about what you guys are doing, as well as the crypto market. But we'd love to get to know you a bit better. Tell us where you're from and where'd you grow up?
I love talking about where I grew up, so thank you for starting with that question, Tony. I was born and raised in the state of Ohio. My parents immigrated to this country and decided that the perfect place to begin their American dream was a little town called Stowe, Ohio, roughly 8,000 people in the northeast corner of the state. And so that's where I grew up. And that's also one of the reasons why I'm still to this day a huge Cleveland Browns and Cleveland Cavs fan.
Oh man, you must have been ecstatic when they won the Cleveland Cavaliers won the 2016 championship, right?
Yeah, I was actually moved to tears, Tony. I will just share very briefly that two things about that moment were striking at the time and still are striking to me to this day. One, I actually went to LeBron James' rival high school, although I graduated a few years before LBJ, and it took me a while to get over that rivalry to root for LBJ, but I'm always going to be a fan of the King for that reason. And two, when it became clear that the Cavs were actually going to win that last game, I kicked my whole family out of the living room just so I could have a moment alone to be with myself and my feelings. So it was a great day. It was a great day.
Yeah, it was a pretty epic championship. One of the greatest finals I think we've ever seen. So that's awesome.
Yeah.
Tell us about your professional background. Obviously, you've been in the tech space for a while. I saw Facebook and so forth. How'd you get into being into the legal aspect of it as well?
Yeah, well, I've now been practicing law in one form or fashion for over 25 years. And, throughout my career, I've always been involved in tech. Most of my clients, when I was trying cases as a trial lawyer, were in the tech industry. And after I left private practice and became a federal magistrate judge for a time, I was largely presiding over cases that involved big tech companies and big tech company disputes. So it was a natural for me when I decided to return to private life, as it were, and work in the industry directly, that I would focus on issues involving technology, first at Facebook, and then now here at Coinbase.
Oh, that's awesome. And what was your first encounter with Bitcoin, and what was your aha moment? And did that lead to you wanting to work in the crypto industry?
Yeah. So my very first encounter with Bitcoin was in a bit of a different place, maybe than for some of your listeners. I was actually in a federal courthouse. I was sitting in my chambers, reviewing search warrant applications one morning, when I came across somewhere in the middle of the pile a different kind of application. This must have been back in 2012, maybe 2011. I was a relatively new judge at the time, and an agent from one of the federal investigative agencies was seeking permission from the court, from me, to seize something called Bitcoin, and claimed that it was either the product of a federal crime or evidence of a federal crime in some way. And so, like anyone who encounters a new idea or a new term for the first time, I Googled it. And that is where, I started my journey into crypto, and found the white paper, got drawn in, got intellectually engaged, and at some point, thought, this is something I really would need to dedicate myself to. And I can't say that, years before I ended up coming to Coinbase, I knew that I would work in crypto, but that seed was planted in a very strange setting. And here I am today.
Wow. When did you join Coinbase? Was it like a few years ago? And
yeah,
was there sorry, go ahead.
I apologize, Tony. I came on board in 2020. So I first met with Brian Armstrong and Emily Choi, our CEO and president, in early 2020, and joined the company later that summer.
Oh, wow. It seems over the past 2 to 3 years, a lot of people have made the migration over to crypto from TradFi, from different industries and so forth. It's pretty amazing to watch that happen.
Yeah, I'm grateful I got the opportunity. And, for me, it was first and foremost about the idea that you could have a permissionless, trustless, distributed ledger and that people could actually accept that as a store of value or as a form of payment. That was really just a mind-blowing concept. But even beyond that, for me as a lawyer and as someone who had dedicated his life to the law, I could tell already that there were going to be some very challenging issues, legal issues, regulatory issues, policy issues involving crypto. And I just wanted to be a part of that.
Yeah, a lot of issues because of the disruption of money and the movement of value. I was recently interviewing the co-founder of Tether, and we were talking a bit about it. We got a bit philosophical, but one of the things that was mentioned is why there's such a big pushback on this is for the first time in history, outside of kings and governments, anyone can create their own currency.
Yeah, it's true. When you start talking about people's money, you tend to get their attention, right? And I think for governments, right, the money system is really one of only a handful of core values that governments and sovereigns offer to their people. And so it really does get at some fundamental questions about our relationship to one another and our relationship to our government in ways that tends to provoke a bit of controversial conversation from time to time.
Well, speaking of that with governments, you recently testified before Congress. I would love for you to tell us about, the what was discussed, what were some of the takeaways that you had, and even the larger theme of what we're dealing with right now.
Yeah, it was a great privilege and pleasure last week to testify before a new subcommittee of the House Financial Services Committee, which generally has responsibility for all things financial systems for the House of Representatives. This new committee is focused on digital assets, on financial inclusion and fintech. And Chairman Hill invited me, along with the ranking member Lynch, to testify about our experience at Coinbase attempting to get rules that we could follow and that others could follow in offering digital assets, and in particular digital asset securities, to the wider investing public. And so it was my great privilege to appear before the committee, talk a bit about our experience trying to engage the SEC and others in a productive way, and where we saw some real gaps in the legislative and regulatory framework that applies to crypto here in the U.S. that Congress could and should fill.
Yeah. And, to that point, we got the regulators all saying different things. There just seems to be a lot of confusion, and entrepreneurs and innovators are scratching their heads like, what is going on in the United States? Should we go overseas? Should we go to Singapore? Should we go to Japan? Whatever it may be. Are you optimistic that Congress will act this year and we could get some clarity?
Well, first of all, for any entrepreneurs or developers listening who are feeling that same confusion or even frustration that you described, I feel for you. I hear you. Because again, as someone who's spent 2.5 decades practicing law, wrestling with statutes, attempting to apply precedents to new fact patterns, I'm confused. I'm even frustrated. So I guess what I'm trying to say to everybody out there is you're not alone. Look, am I optimistic that we can fix this? Absolutely. It's one of the reasons why last July, Coinbase actually filed a formal petition for rulemaking, which is a legal process that asks the SEC to issue or promulgate a bunch of rules that we could all follow on some such basic questions as how do you define what is a security and what is not? And what's a path for registration? How do we keep investors and consumers safe, even as we protect innovation? We asked something like 50 specific questions that we thought the SEC could and should answer in developing rules. Unfortunately, we haven't gotten any response back from the SEC on that petition. But over the course of the long term, I am optimistic that Congress will solve this problem if the SEC chooses not to.
For sure. So talk a bit about Coinbase's process in judging if tokens are securities and if they're not. And I want to make sure I give some context to this. This is a vastly new technology. Tokens are distributed globally on the blockchain. Even the SEC at one point under Bill Hinman and Jay Clayton said, tokens and projects and start as security, but over time morph and become decentralized where they're not securities. So we need the guidelines, we need the sandbox, as Hester Pierce has developed or put forth. So how does Coinbase as an exchange navigate this, and are you worried that things that you view as not securities will be called securities by the SEC?
Well, one of the things that I'm proudest of here at Coinbase is that we do have a very extensive asset review process. For any asset or issuer that wants to list an asset on Coinbase, there's a detailed process that begins with submitting all kinds of information about the history of the project. There's a requirement that a white paper be included, and lots of facts about the state of the project, how the network will be architected, what are the basic tokenomics, all these sorts of things, so that we can take those facts and then apply the legal standards that have trickled out of our system in order to make a determination as to whether the asset is or is not a security and therefore appropriate to be listed on Coinbase. Now, the reason we do that is Coinbase is not a national securities exchange or is not otherwise registered. And so we don't offer securities. We work very hard to make sure that what we offer falls outside of the rules that have trickled out of the process that I've mentioned. Now, the challenge for us, Tony, is that the process as it exists today consists of laws that were written in 1933 and 1934, Supreme Court precedents that are not much younger than that, and a handful of statements that come from reporting by the SEC, speeches by individual commissioners. It's a pretty huge challenge for us to try to figure out what the law actually is today because we don't have clear rules. But we do that. We run that process to the best of our ability. We work with outside lawyers. We have experts here at the company. And at the end of the day, we make a call as to whether or not an asset is or is not appropriate for listing based on what we've reviewed. Now, to give you some sense of how diligent and rigorous our process is, you know better than anyone that if you look out into the universe, there are thousands, perhaps even tens of thousands of different tokens and projects now that could be listed on Coinbase. A much smaller percentage of them, maybe 1,000 or 2,000, have indicated an interest in being listed on our exchange. And no more than 200 or 300 have been accepted to date. And so it's a very tiny percentage of tokens that actually makes it through that process. And that's even before we get to other review processes that we run, looking at compliance issues, looking at cybersecurity issues. And so it's a pretty tough gauntlet. And so that's one of the reasons why once we have reached a conclusion that an asset is appropriate for listing, we're confident that we're on the right side of the law as best as we can evaluate it.
One of the things that Hester Pierce, SEC Commissioner Hester Pierce, mentioned in one of my interviews with her is that she's trying to get the other commissioners and the folks at the SEC to view not the tokens themselves as inherently securities, but rather how are they packaged? What is the contract? What scheme is behind it? Because it would be the same as saying the oranges or the orange grow inherently are securities, but rather it was how we package it. But it seems Chair Gensler and the other commissioners are trying to just say inherently by default, as soon as a token is minted, it's a security.
Yeah, I think Commissioner Pierce was early on this very important issue. And since she first began making, I think, noise about this or raising concerns about the misapplication of the law, others have picked up on this idea that there may, in fact, and we know that there are offerings out there that qualify as investment contracts. And of course, investment contracts are just one type of security, but they're the one that tends to attract the most scrutiny as applied to digital assets. That doesn't mean that the tokens themselves remain or embody securities for all time, for all purposes. And as you point out, Tony, of course, the nature in which tokens can be offered can evolve, often does evolve and change over time, so that what may have started out as a potential security may no longer be one, as the project has decentralized and the tokenomics have changed. The important point of all of this is right now, today, we have no rules from the commission or anybody else that it lays out or explains how to think about these issues in a coherent, reasonable way that, again, isn't just about pumping tokens out onto exchanges like Coinbase, but rather accounts for the need to protect investors, to make sure they have important, information about the projects, that the disclosures that are made are informative and helpful to the investing public. And yet, we all have to try to navigate this as best we can. If we went through a proper rulemaking process, we could get to a much better place. I think Commissioner Pierce and others have been quite eloquent and persuasive in explaining that if we don't do this, if we continue in this sort of random path that we have up until this point, we're going to see other countries leap ahead of the United States with sound regulation, reasonable rules in ways that are going to start to draw capital and investment to other places outside of our country.
Mm-hmm. And recently, well, actually, let me back up. Do you think some of the confusion here is these individual agencies like the SEC, the CFTC, and whoever else? It's a bit of a land grab. Like they want to control the asset class, the market, because you have the SEC. Once again, they have their stance. Everything's a security. And an example I want to give is Ethereum in the recent KuCoin lawsuit from the New York Attorney General. They're citing Ethereum as a security in that lawsuit, but Rostin Benham, chair of the CFTC, saying, no, it's a commodity.
Right.
And it's like, wow, this is such a mess. But do you feel there's a bit of a land grab here, or a plan to get more power for each agency is trying to do that?
Yeah, I mean, look, I always want to assume good intent, and I as someone who served in government, I do believe that our officials, by and large, are trying to do the right thing. But I can't ignore, any more than you or anybody else can ignore, the fact that it sure seems like the officials who are responsible for giving us clear direction and then enforcing those rules consistently can't seem to agree among themselves as to what the state of the law is or what rules actually should apply. You point out, for example, that we have the chair of the CFTC stating in testimony before the Senate Banking Committee that Ethereum is not a security, that it's a commodity. At the same time, I think within the same week as the New York Attorney General declaring in a court filing that Ethereum is a security. Then you have over at the SEC a blanket statement from the chair at one point in time that Bitcoin is the only non-security and that every other digital asset falls within the SEC's jurisdiction, meaning everything else is a security. The chair himself, though, at other points in time has suggested that Ethereum is also a commodity and not a security. So it's a mishmash, to use a technical term. And I just wonder, how any of us can feel good about a system or a state of play in which the most senior officials responsible for enforcing our laws can't seem to agree on a basic question. And yet the rest of us are being told it's all very clear. We don't need any new rules. That doesn't make sense to me. I think we can do better. Absolutely.
Let's talk about XRP. And I know this is very controversial and sensitive topic because of the ongoing lawsuit. Coinbase listed XRP, was available for trading. The SEC filed a lawsuit. Even the details of how that filing took place with Jay Clayton is a bit fishy, but that's another conversation. Coinbase then halted XRP trading. It's still an asset listed on your site. Talk to us about that. Was that a legal thing or more of a risk mitigation thing? Like, okay, as a business, we need to protect our company. And while we may view XRP as not a security, we have to halt trading. Is that the premise behind or the thought process behind it?
Well, as I mentioned earlier, Coinbase regularly evaluates assets not only for initial listing, but potentially for delisting or pausing when we come to learn new information and new facts and circumstances. I know that for many holders of XRP, it has been frustrating that they have not been able to trade their assets on Coinbase while this SEC case has been pending. That hasn't stopped Coinbase from carefully monitoring the state of the litigation. And as much as anybody else who's been following the docket in that case, I've certainly paid attention to the fact that the defendants in that case have done a masterful job of pushing the SEC and raising serious questions about the SEC's entire theory that undergirds that case. In fact, I was so persuaded by those efforts that Coinbase filed its own brief in that case in support of several of the important defenses that Ripple and others are raising. So we have a strong interest in making sure that these issues get resolved in the appropriate way. I've admired the way that the XRP defendants have defended that case. Just as a lawyer practicing his craft, I can't help but observe that Stu Alderati and the others at Ripple have just done an incredible job of mounting an effective defense. And I'm hopeful that the court in that case will see that the SEC's theories have serious issues. I think the briefing in that case has been excellent. And we're all going to find out soon what the trial judge thinks of the arguments that have been made. I would just call out, though, for those listening, that the decision of the trial court is just the first step, I suspect, in a longer process. This case has a very high likelihood of being appealed, regardless of who wins or loses at the trial court level. And so, as much as any of us would love to have resolution of that particular issue soon, I suspect we're all going to be in for a little bit of a longer wait as the case plays out further in the appellate courts.
So let's say in a scenario, the ruling from the judge is in favor of Ripple. Will Coinbase then make the assessment, you know what, it looks like things are moving in the direction of XRP and Ripple and so forth, relist XRP or restart trading?
It's possible. It would all, of course, depend upon the basis for the ruling, the judge's legal reasoning, our assessment of whether or not an appeals court would affirm that decision. So a lot's going to depend on the particulars of how that court rules. I know that's not going to be terribly satisfying to some, but we do have a responsibility as a publicly listed company to tread carefully in this area and with respect to any token that's the subject of federal court litigation. But I'm very, very eager, as much as anyone else, to see how the court rules. And what I can say is, as soon as we have that ruling, we will put it into our process to see if we need to revisit our listing decision.
I'd love to get your thoughts on the dynamic of, which I don't think the SEC or anybody saw coming, and that is token holders crowdsourcing and causing and having an impact on the case via attorney John Deaton. I didn't see that coming. And I'm like, wow, there's like 70,000 plus XRP holders, and they're all on Twitter, and they're all so it's a very different dynamic. Have you seen anything like this before? And what do you think the impact will be moving forward? Once again, it doesn't have to be XRP. It could be Cardano. It could be whatever. What do you think about that?
No, to answer your question directly, I have not seen anything like this in my experience. And again, even though many of the holders of these tokens and the fans of the projects are quite aggressive and quite vocal, I respect what they're trying to do. In a lot of ways, Tony, this is what democracy is supposed to look like, right? Regular people weighing in on important issues that impact their lives. So I have a ton of respect for what all of these communities have been able to do in terms of influencing the direction of the litigation, the arguments that could be made, even the mastery and the building of the record of evidence in the case. It's really quite impressive. And attorneys like John Deaton and others, I think, have done an excellent job representing that community's interests. So my hat's off to them.
Of course, the XRP Army folks wanted me to ask you, and I don't know if you have an answer to this, but Coinbase did publicly state that they were going to distribute the Flare tokens, which were which were kind of due to the XRP holders, due to a hard fork and things along those lines. Any updates on that, when that may take place?
I don't have any update on that that I can provide today. What I can say is that we take the concern seriously, and I know that may not be satisfying to some who want to see relief today or frankly yesterday. But this is a process that we run across all tokens. We treat everyone the same, And it's important that we tread carefully and appropriately, because again, we are in a slightly different position than many other parts of the crypto economy. We're a publicly listed company. We have obligations to not only our shareholders, but to other stakeholders in that capacity. We are going to treat everybody appropriately and equally. And as soon as we have any further announcements, maybe I'll come back on your podcast, Tony. We could talk further about that.
For sure. I'd love to get your thoughts on staking and how the SEC views staking, because I know at one point, Brian Armstrong, your CEO, had tweeted out about the SEC and potentially blocking Lend, which I know is an entirely different service. But it seems like the SEC is trying to stop crypto lending, crypto staking to a certain degree. What are your thoughts? And, are you with the Kraken settlement, does that affect Coinbase in any way?
Well, we certainly we're very concerned, and we saw the SEC's statements and then ultimately actions against staking, even though Coinbase's staking product operates in a fundamentally different way. There are certain elements of it that we think clearly distinguish it from the staking product or service that was at issue in the Kraken settlement. For example, with the Coinbase product, the network actually sets the rewards that are to issue. And to the extent we take any commissions off of that, those are disclosed on our website. So our customers know exactly what it is they're entitled to. And there's no question or concern that somehow Coinbase might exercise discretion or on a whim deny them or deprive them of what they're owed. That's very, very important. At all times with the Coinbase product, title remains with the customer. It's not as if we take ownership of that asset in some way and vest title in Coinbase versus keeping it with the customer. And that's a legal distinction that may sound technical, but it matters. We're confident that the law would recognize that. So there are any number of other arguments I could raise as well to distinguish the Coinbase product from what was issued in Kraken. That didn't mean, however, that we weren't concerned that the SEC was suggesting that somehow staking generally brought Ethereum or other digital assets that rely upon a proof of stake mechanism inside of the boundary of the securities laws, because again, the law is very clear that the way that the products and services work matters, and we think that if that is the SEC's view, and again, Tony, here's the problem. I can't tell you what the SEC's view is about staking generally because they won't tell any of us.
Yeah.
I think it would be misguided. This is yet another reason why we would love to see a public process initiated that allowed the Coinbases of the world, as well as anybody else with an interest in this subject, to weigh in, to offer comments, for there to be a public, transparent process so that everybody could understand the issues. And at the end of the day, if the SEC were to make a rule, we would follow that rule. But right now, you and I and everybody else are left guessing. And I just don't think that's the best that this country can do.
Mm. Do you think it makes sense for Coinbase to be the leader in crowdsourcing other crypto companies and exchanges, and potentially suing the SEC for the clarity? And look, there's a lot of confusion, right? And I was kind of disappointed that Kraken settled, and I wish they had fought, but maybe I don't have all the details. But does it make sense? And this could take years, and it could be probably pretty expensive. But if you guys crowdsource your resources, could that work?
Well, Coinbase is prepared to fight where we think the law has been twisted and abused in a way that no court would tolerate. But we don't want to fight. I mean, to be very clear, Tony, like my first, second, and third preference is to reach a reasonable accommodation in a conversation with the SEC through dialogue, and not just me and someone from the SEC sitting down in some smoke-filled back room. I'd rather do this in a public process where your listeners, members of the XRP army, our friends over there, and anybody else with a stake in this thing can offer their opinions and weigh in. All that said, the definition of a security is obviously something critical to this industry and this economy's long-term success. And we believe if the SEC insists on misapplying and misstating the standards, at some point court process may be necessary. I don't look forward to that. I don't think that a lengthy court process is the right way to resolve these issues, but we are prepared to do that if necessary. And of course, if we were to end up in court, I think there would be an opportunity for a wider circle of participants to be involved. But we aren't going to require that. We will stand up for the rule of law.
Yeah, and certainly to your point, like that's probably a last resort, right?
Totally. No, because and it's not because I don't love being in court. I mean, I was a trial judge, I was a trial lawyer. I love court process. But the problem with litigation is that it takes, in some cases, years to resolve. Look what's going on in the XRP Ripple case, right? Like that case has now been pending for several years. I mentioned that several more years may lie ahead in the form of appeals and the like. That doesn't give anyone clarity or certainty in a way that we think is important to allow for the industry to grow.
Absolutely. I'd love to get your thoughts on the Grayscale lawsuit against the SEC for not or disapproving their Bitcoin spot ETF application. What do you think about that? Do you think Grayscale can win this?
I think Grayscale has similarly done a masterful job of presenting their arguments. Craig Solomon and the team over there have, I think, assembled some of the brightest lawyers I know of in presenting their case to the DC Circuit Court of Appeals. And based on the reporting that I've seen, I haven't yet been able to listen to the arguments or see a transcript. It seems as if they were quite effective in making the case that you can't treat a spot market ETF differently than a futures-based ETF simply because you don't like one and you're comfortable enough with the other. The notion that somehow one market is more subject to fraud or abuse versus the other is somewhat laughable if you have any basic understanding of how futures markets work and the way in which they relate to the underlying spot exchanges. So I'm hopeful that the judges of the court will ultimately be persuaded of that argument. I think it's more consistent with the law. I think one of the things that your listeners should appreciate is that, the judges who sat on that panel are all excellent. They have outstanding reputations in their own right. And so I think that suggests that, Grayscale has a real fighting chance here. They got good judges who take their duty seriously. They presented excellent arguments from some of the best lawyers, and the most important thing in any litigation is they have the right facts. Like they're actually right on the merits, and so fingers crossed that they prevail.
Personally, I'm hoping that both Ripple and Grayscale are able to walk away from these with a victory, and I think it will help the industry a lot, and maybe it will force Congress, seeing a regulator like the SEC taking these large hits and losses, to act, maybe light a fire under,
It's I'm hopeful as well, Tony. And at the same time, I don't want to write off the SEC either, because I think sometimes it can be tempting to assume that, the hundreds or thousands of people who work at the commission all are of one mind. And of course, the political appointees and the leadership have an outsized role in the direction of the SEC and what it prioritizes and how it thinks about certain issues. But I've worked with many, many staff members who have spent, years or in some cases decades of their career at the commission. And I've been impressed at their interest in doing the right thing and applying the law as it actually it works. And so, there's still hope, is what I'm trying to say, is that we shouldn't write off the SEC entirely just because of certain political arguments that have been made over the last few years. There's still a chance for them to get this right.
For sure. They also the SEC also put out some proposed custody rules. I've spoken to a few custodians, they're positive on it, BitGoes, the standard custody and so forth. But I think from an exchange standpoint, it's not entirely great. Tell us about that dynamic.
Yeah, so the SEC recently proposed a rule for registered investment advisors and essentially laid out the standards that those RIAs have to apply in selecting a qualified custodian. And there was a lot in the proposal that we actually liked too. For example, there was a recognition that state chartered institutions like Coinbase Custody Trust Company, our New York state chartered trust co, can qualify and can serve as a qualified custodian, assuming they otherwise meet the rules. So we think that's positive. The fact that the SEC took this position in the form of a proposed rule through notice and comment rulemaking was also very positive, because it showed me, and I think many others, that the SEC understands full well that a public, transparent process that invites comments and input and so forth is the right way to get to the right result. Now, as you point out, there are still serious flaws with what's been proposed. For example, I don't think that the proposed rule properly considers the realities of how institutions want to hold their assets and how they want to trade them. And so we do think that some adjustments need to be made in order to accommodate or adapt to market realities, and also the reality that states can play have played a very important role in making sure that these institutions are regulated properly, that there's sufficient oversight, that no one's gaming anything, and so we think that needs to be considered as well. The last thing I'll just say about the proposed rule from the SEC is that it is a proposed rule. It is not a final rule, and so this is going to take many, many months to resolve. And so even though we have these concerns, again, I have to believe in our system, or else I wouldn't be a part of it. I'm hopeful that as we work through this process of notice and comment rulemaking, we're going to get to the right result in the end, even if over the course of it may be a little frustrating.
I know we're running up on time, so got a few more questions here for you. What's on your roadmap, as far as your priority list for the remainder of the year?
Well, I certainly have to point out that over the course of the weekend, where we saw a number of banking institutions fail or be put into involuntary receivership, making sure that crypto firms continue to have access to banking services is a top priority for me and for the people that I work with. Coinbase itself is fine. We're somewhat fortunate in that as a public company with billions of dollars on our balance sheet, we have and continue to enjoy access to banking services that we need in order to do the basic things that any company needs to do: make payroll, provide payments to suppliers, all those sorts of things. But a lot of others in crypto, I think, are feeling pressure from what seems to be an effort on the part of different parts of our government to cut off banking services and deprive them of the basic functions that any company or organization needs. That's concerning to me, and I'm certainly going to be paying a lot of attention to that. I'm hopeful that coming out of the events of the past week with respect to banks, stablecoin legislation will remain a priority for the Congress. I talked about this in my testimony last week. I think that there's an opportunity for Democrats and Republicans alike to agree on basic standards for stablecoins that would promote confidence in things like USDC and other dollar-backed digital assets. And so that's going to be a priority as well. And then the final thing I would call out over the course of the next year is continuing to educate and inform policymakers about the opportunities of crypto. I don't think we've done a particularly good job in the crypto industry of talking about all the positive ways in which digital assets can improve networks, can improve basic services that real people rely upon. And so we're going to be making that case and continue to make that case, even as we defend against subpoenas and other legal process that go at more technical issues or concerns under the securities laws. We need to be positive. We need to talk about why this stuff matters, and I intend to do that.
Yeah, I've definitely, there's a need for that, because I think a lot of folks see just crypto bros or tweets and memes, and we got to go beyond that.
Yeah, for sure. This technology matters. And, like a lot of new technologies, we're going through some growing pains right now. But I think if we can explain why crypto can actually create opportunities for people, bring more people into the financial system who have been traditionally excluded, I think we have a real chance to do some good. And that's what I intend to do.
Tough question for you. And I heard recently that Kraken plans to become a bank. Is Coinbase, do you guys have those similar type of plans?
I've read the public reporting from on Kraken's plans, and wish them well. We don't have anything to announce along those lines right now, but I think a lot's going to depend upon the mood in Washington and the appetite of policymakers to allow crypto to integrate with the traditional financial system. We tend to focus a lot on the risks to the traditional financial system from crypto, but the reality is that as we saw this past week, there are real risks to crypto from the traditional financial system when basic banking services are suddenly at risk. So that's something we're going to pay a lot of attention to. And I'm hopeful that once we get past some of these more immediate crises or concerns, the regulators are going to take a more, I think, holistic view of how these two systems can and should work together, and we'll see what goes from there.
I got some wrap-up questions here for you. If you could create your own metaverse, what would the theme be?
The rule of law. I'd love to see. I still have to see standards somewhere in the real world, but if we have to go to the metaverse for it, I'm out for it.
And some rapid-fire questions here for you. Favorite food?
Oh, pizza for sure. I could eat a pie a day if I were allowed to.
Favorite musician or band?
I would say the Police, and Stuart Copeland is maybe my favorite percussionist of all time. So that's who I would pick.
Awesome. Favorite movie?
Hard.
Yeah.
This is a tough one. I'll pick Casablanca because I thought Bogart was just an amazing dude, and I still kind of admire the way he carried himself in the casino.
And favorite book?
Right now, I'm reading a book about Lee Harvey Oswald. It was written by a former judicial colleague of mine, Bill Alsop, who still sits as a federal judge in San Francisco. It imagines what would have happened had Oswald survived after his assassination of John F. Kennedy and been put on trial. So that's one I would recommend.
That sounds interesting. And finally, when you're not at Coinbase, what are you doing for fun as a hobby?
Usually I'm sweating, trying to exercise and keep in shape so that I can live to fight another day. But for pure fun, I love listening to live music.
Awesome. Paul, pleasure chatting with you. Thank you so much for joining me.
Awesome. Thank you for having me, Tony.